So we are studying landmark judgments, and for UPSC specifically we are also watching their effects, because for UPSC not only the judgments but their effects are also important. And this is the third case, Golaknath case. We are going to discuss about Golaknath case. And before this we also had covered Ramesh Thapar Srimati Champakam case, Shankari Prasad versus Union of India case, and now we are into Golaknath case. And do check all these videos also, because we are not only studying the cases but also the effects they have on our society, on our judiciary, on our people, on our country. And it's important to know how things developed in between two cases, like what are the developments in this particular case, and then what happened in this, and then this case happened in 1951, and what happened in between 1951 to 1967. It's important to know, right? And if you want the PDF of this particular lesson or any of my lesson, you can contact on my Facebook ID. The link will be given in below in the info section. You can also add me there, and if there is any suggestion about any of the courses, you can also give me there. So we are into our third case, the Golaknath versus the state of Punjab 1967, right? This is the name of the case. And what are the developments till now, till 1967? The 9th schedule, right, is added in our constitution. In Ramesh Thapar case, right, in Ramesh Thapar case and Srimati Champakam Dorai Rajan case, the first amendment happened. And then in Shankari Prasad case, the full amending power or absolute power to the legislature was handed over by the judiciary. It says that now you can amend anything, we will not review it. And there is one more thing before starting this particular case I want to discuss, that since obviously I hadn't downloaded any information from anywhere else, I also watched many YouTube videos on Golaknath case and read blogs and websites. And there was a common problem among students that they know that in 9th schedule a law was added by parliament. It is all written everywhere that the parliament can put any law which it doesn't want to go under the radar of judiciary into the 9th schedule. And then in the Golaknath case, they read that the state of Punjab put the Land Reform Act in the 9th schedule. So, I had seen many students with a very common question among them. And the question is how a law, how a state can put any law into the 9th schedule. So before starting this Golaknath versus state of Punjab case, let's have a discussion on how a law is put in 9th schedule, how a state can put a law in 9th schedule. Like, so there was two scenario before 1976 or till 1976 you can say, and after 1976, right? So what happened before 1976? The law is passed by state government, right? Because any law it want to any bill is there in the assembly and it was passed by state government, then law is sent to president for assent, right? This is the second step. Then the president sends it to the council minister for consideration, which if gives assent becomes a law, right? This is the common procedure, you are aware of this. Now if challenged in court, if there is a possibility that the particular law breaches fundamental right, any sort of, and up to Golaknath case, the right to property is also a fundamental right? It was deleted in 44th amendment. So up to this time 1967, the right to property is also a fundamental right. And therefore if challenged in court but deemed fit by government, if the government feels that this particular law violates the fundamental right but at the same time is necessary for the greater good of society, it may seems fit to the government, and then the government will add the particular law, say any particular law related to land reform in article 31B by amendment, right? That is the process. If a state wants to add any particular law into the ninth schedule, it cannot do it on itself. It may pass the law, then it will send the law to the president, then the president send it to the council of minister for consideration, and then it will become a law, right? Then if the parliament, the parliament believes that this particular law is necessary, then the parliament will add it into the 31st in article 31b by the means of an amendment. They have to amend the constitution to put any law under ninth schedule. So this is the process of putting something in ninth schedule. Now moving on to the case, and okay, there is one more scenario. I said that there was two cases before 1976 and after 1976. So what happened after 1976? There was an amendment, and it was made obligatory for president to give his assent to constitutional amendment, right? Before 1976, it was not mandatory on the part of president to give assent to constitutional amendment, but now after 1976 it was made obligatory for president, right? Now what is the case? Family of Henry and William Golaknath held over 500 acres in Punjab, right? They are two brothers, Henry and William Golaknath, and they have approximately 500 acres of land in Punjab. And in 1953, Punjab Security and Land Tenure Act, state government says they can keep only 30 acres each, and the rest of the land will be distributed among the workers on the field, right? So just have a welfare scheme, and there must be an equality among different peoples in the society. The Punjab state decided that they will distribute the excess land into the workers working in the field of, or in the farm of, Golaknath brothers. Now obviously the fundamental right of property was there, and this particular act was violating the fundamental right, which is of right of property. The the Golaknath brothers will go to the court, right? So what was the issues involved? Since Punjab Act was placed in 9th schedule, and I had discussed this particular thing in the last video, Shankar Prasad video also, that if something is placed into the 9th schedule, we cannot, or the Supreme Court cannot review it, it cannot scrutiny it. So since the Punjab Act was placed in 9th schedule by 17th amendment, the issue don't involve the validity of that particular act, but the issue are whether amendment is a law or not. In Shankar Prasad case, the Supreme Court says that amendment and law are two different things, two separate things. So the issue here is whether amendment is a law or not. They amended the constitution by 17th amendment. So whether the court will declare it null and void under article 13 or not, whether it is the same thing or not. Then the next issue is whether fundamental rights can be amended or not, and this one is an important issue involved in Golaknath case. So these are the issues, and moving on to the next thing, what are the judgments? The Supreme Court reversed its earlier decision of Shankar Prasad case, and now fundamental right cannot be curtailed, right? Remember this particular point. This is the main point of whole Golaknath case, that in this particular case Supreme Court says that fundamental right, you cannot curtail down fundamental rights, right? Then Supreme Court also reversed its previous decision on Shankar Prasad case and said that there is no difference between law and amendment, and the 17th amendment is still valid. So they hold that 17th amendment is still valid, and therefore the law put under the 9th schedule is still valid, and therefore the land will be taken from Golaknath brothers and will be distributed to the workers in the field, right? So these are the judgments, and there is a constant tussle between judiciary and legislative. You will see this particular pattern in upcoming Keshav Nanda Bharti case and Vaman Rao case, and even in leave these cases are strictly related to the judiciary and legislature. If you see the Shah Bano case, even the Shah Bano case, which is responsible for the advent of BJP and the demolish of Babri Masjid, it has very greater effects. And if you see Shah Bano case, even in Shah Bano case, the Supreme Court gives a judgment, and the legislature comes up with an act to neutralize this particular judgment of Supreme Court. So this constant tug of war between judiciary and legislature was there. And in this particular case, the judiciary, in the previous case, Shankari Prasad case, the judiciary gives the legislature an upper hand. It permits the legislature to do whatever it wants to do in the name of amendment. But in this particular case, the judiciary curtails down the power given to the legislature. Right? What are the effects? Parliament passed again the very same feature, the tug of war between judiciary and legislature. So the effect was Parliament passed 24th Amendment in 1971 to abrogate the Supreme Court judgment. It amended Article 13 and 368. Right. So this is the effect of Golaknath case, that since the judiciary says that there is no difference between law and amendment, and the reference of law was given in Article 13, and the reference of amendment or the mention of amendment is in Article 368. So now legislature say, okay, we are going to amend these two articles itself, right? So in 24th Amendment, our legislature amended Article 13 and Article 368, right? So if you want to take one particular line from this Golaknath case, it is that now fundamental rights cannot be curtailed down. The Supreme Court says you cannot touch fundamental rights. That's all for this particular case. Let's meet you in the Keshav Nanda Bharti case.